Well, good evening, everybody. Welcome again. And my name's Frank Taney, and I'm a partner here at this law firm. And tonight I'm going to be talking to you about the legal and ethical considerations with the use of social media and also the implementation of social media into a business environment. It's the little housekeeping thing. If you care to tweet about it, please use the Jenna Communication social media hashtag, which is a nice long hashtag, but gets the point across. Um, I'm even homelier in person, but that's my picture. Just by way of not by way of tooting my own horn, but by way of background, so you can understand my perspective in my remarks to you tonight. I have two aspects to my practice here. One is trial work and commercial litigation. So, and there is a heavy information technology and web and social media focus to that aspect of my practice. I bring that up because I'm currently representing people who are embroiled in disputes, arising out of the, improper use of social media. I've seen what happens when these disputes blow up. Tried cases involving these things to juries. So I have a very firsthand knowledge of exactly the real world consequences and ramifications of improper use of these things. And I also, the other half of my practice is transactional and counseling. So I am working with a number of professionals and companies that are using social media for a variety of purposes. And so I get to see firsthand some of what I'd consider some of the cutting edge uses of this technology and these applications, and some of the business and operational issues that these people and these companies are facing as they try to use this stuff for other than greasy kid stuff. Because I mean, these are while there's a consumer, there's a fun angle to all this stuff. Uh, there is a science underlying social networking techniques and social networks. It gets quite a bit of attention in the Fortune 50 and Fortune 500 environment, and the university and research environment. So it's not just yucks and laughs. There's money to be made. There's business applications for these things. So my remarks to you are from that, or informed by those aspects of my practice. So diving right in, when I look at social media applications and how they're deployed, I see, and there's a variety of ways people are deploying them, but I see tremendous potential. Um, Apart from there is a lot of times people focus on, okay, I want a Facebook page or a Twitter feed to just publicize my company's brand, and there's certainly a lot of that. Uh, there are other uses though. If you've heard of, if you know Wikipedia, that's one form of wiki. And what a wiki is a sort of a blog, a user content generated blog, and a lot of times companies will use that internally to capture sort of institutional knowledge that would otherwise go unrecorded. That's one use, or internal blogs or internal facing social media applications that enable employees to interact, to brainstorm, to collaborate especially where there's organizations that are geographically spread out, and these people would never meet, and it costs too much to put them on a plane or a train to assemble. So I see that's what I mean by encouraging and capturing the benefits of employee innovation. Um, apart from just mere brand enhancement and advertising, companies often use social media to um, and those types of techniques to generate useful ideas and feedback from the user base, the customer base, even non-customers and users who have knowledge. Procter and Gamble is a well-publicized example of company that uses social media to crowdsource information, crowdsource inventions. They'll put out a call over social media. We're looking for inventions in such and such a field, and they'll get good ideas, and if the ideas are attractive enough to them, they'll enter into some agreements with people. Um, if you have people out, companies have people out on the major social media platforms trying to engage the customer base and engage the community, saying, what do you think about our latest release? What do you think about the product? Are there problems? What could we be doing better? What don't you want to see again? So, um, you know, do you have any suggestions for us? And companies are out there using that kind of information to get free R&D, free advice, or almost free, because they are paying their employees to be involved. Uh, this third bullet point is the more traditional, what a lot of people think. Like us on Facebook, or follow our Twitter feed, or follow us on, connect to us on LinkedIn. There is certainly, you can do that with customers to the extent you encourage employees to participate and sort of cheerlead and identify and be involved further with the company. I see a lot of useful deployment of social media around there. Um, and the ever popular much more, I also see companies using, people don't think about this, but use social media as a business intelligence gathering tool. In other words, if you see that you have a customer, if you have a major customer and you see how they interact with social media, you'll get clues about what they're going through, what their challenges are. Similarly, if you have a competitor and you see, if they're indiscreet enough to, um, you know, deploy social media in a way that enables identification of customers. Uh, you know, I've seen businesses use social media for business intelligence. And business intelligence is, it's not always somebody leaving the Coke formula or the Pepsi formula out on the web. It's disparate pieces of information, one left here, one left there, one left the other place, that if somebody's looking at it, intensely enough, and as a cohesive whole, you can figure out a lot of things about your competitors, your customers, and trends in the industry. So there's that aspect to um, social media. Well, in some cases, the Procter and Gamble example, I mean, so there's a call, they sort of vet or screen, and they say, okay, we got 10,000 submissions, we like these 35, and they'll contact people. So you know those people, those companies skilled with that crowdsource stuff, they have it down to a science. Some people are sort of doing it, and as I'll get to later, they don't necessarily bolt everything down and have a clear understanding of who has rights to an innovation. Do we have a joint invention? Do we have somebody with proprietary rights now to something you've brought into your company? And so that's, while there's the benefit, that's sort of the other side of the coin of the risk. So some of what I'm going to talk. So I made that my first slide because sometimes people think lawyers are there to tell you, no, don't do it. It's it's too dangerous. Don't do it. No, I think people who aren't using social media, um, I can't think of a single industry of any consequence where I wouldn't want to use social media. I think if you're not using it, you're missing out on an opportunity. However, with that opportunity does come some risk. And the risks come from both internal and external sources, right? Category, I'm going to give you some examples. Talk about when you have an application that enables, and it's company sponsored, and you may even be telling customer, or you may even be telling your employees, we want you to interact as part of your job with other employees, or other employees and customers or prospects. And this is part of your job, or you're allowing them to do that on the premises, and using their work computer and on their time. that becomes part of the workplace environment potentially. And to the extent that you're not keeping tabs on improper behavior, harassing behavior on the part of employees, you could you could give rise to claims for hostile workplace environment, right? Or if someone defames, someone says something derogatory and false about somebody um, on a a company application internally, and it's brought to the attention of the company, and the company doesn't do anything about it, or the company allows the conduct to persist, the potential arises that there's some vicarious liability there on the part of the company towards the offended employee. Similarly, you can have tort claims arise from non-employees. So if you have um, employees of yours interacting with third parties like prospects or customers or even competitors, uh, you know, just because there may be you may be sending out your employees to interact with third-party social media applications or platforms. In other words, they're finding their way on off your page, off your website, onto others, chat rooms or things like that. Um, if they say things derogatory about in a derogatory fashion about competitors, could give rise to claims for trade libel, for example. Applied to a person and not a business, it would be slander or defamation. Um, Intellectual property disputes. You know, for, the gentleman's question touches on that. Um, what you have you have three. There's four main varieties of intellectual property. Uh, there's patent rights, which can relate to business processes, articles of manufacture, composition of matter, and those protect ideas. There's copyright, which protects original works of authorship. So that's copy. In other words, there's literary works. There are pictorial works. As the name suggests, they're pictures and other things that can be very easily something that is posted on a site. If you have a blog, for example, on your site, and you're allowing employees and non-employees to post there, right? By posting it there, you have to worry about who owns it. Does the person who's posting it own that material? Are you, by allowing that to remain on your site, actually infringing the copyrights of some third party whom you don't even know, right? And it's not, and there is no defense. I didn't know about it. Defense to copyright infringement or patent infringement, for that matter. Another area of intellectual property are trademarks. Trademarks are words, symbols, logos that identify a company as the source of a product or service. Um, you may have people posting things on your site. Maybe they're posting the logo or the service mark of some other company that hasn't given permission. Maybe sometimes I've seen people make fun of things, the logo, change the logo a little bit, or they may be posting it in a way that confuses the public about who is sponsoring these statements. These can give rise to trademark infringement liability. And then there are trade secrets, which are as opposed to the first three categories of intellectual property, which are the subject of public filings. You file a copyright and the world knows what the work is. Trade secrets are kept secret. They're skills or methods or processes that are not known by the general public, but that give the owner an advantage in what he or she or it does for a living. So um, if you have, if your employees are out there improperly, soliciting trade secrets of competitors, for example, or um, you know, uh, somebody con- somebody contributes the trade secrets of someone else, to your site, and they didn't have permission to do so, you have a potential liability situation there. Similarly, the internal threat, They say loose lips sink ships. Your employees talking about what they're doing, innovations they're doing. Once you disclose a trade secret, it is a trade secret no more. And warranty and misrepresentation claims. Um, a warranty in legal terms is simply a promise or a statement about a product or a service. So to the extent you have your employees out there as part of their job to talk about the attributes of your products or service, you have to make sure that they're being accurate, they're not being misleading. Otherwise, that could give rise to potential claims for breach of warranty or misrepresentation. So, and we'll talk about some further examples of these types of things later. But uh, against these risks, there are a number of risk mitigation techniques that I would recommend. So the first thing is you have to um, communicate to your employees a number of things. I'll start with the second slide actually. Um, you have to have an idea as a company. What is your purpose in using social media? And I put up in the very first slide some potential some potential purposes that other people use it for. But are you trying to just um, are you using it for hardcore market intelligence? Are you just using it to put a nice public face on your enterprise? Are you using it to engage your customers, to build buzz around your brand, uh, create loyalty, spread the word? Are you trying to do all those things at the same time? Are you trying to um, correct misimpressions about your company's products or services that are out there in the marketplace? I've seen social media used for all these things, right? Figure out what the goal is. Why are we here, right? We're not, the answer can't be or shouldn't be, we're here because everybody else is doing it. I've heard about Facebook. I've heard about Twitter. I see my competitor has a Facebook page. I'm going to do it too. You know, uh, Figure out what you're going to do. What um, what message? Realize that the internet is and the web is a fishbowl, and what you do leaves a trail. And it's very hard and sometimes impossible to erase that trail completely. So think about if you're going to let one or more employees or representatives speak on behalf of your organization, what message do you want them to send? What uses do you want them to make of these applications? Okay, is it all pushing out content, advertising content, but no real substance, or are they out there to share information about products or services, technical information with customers, or are they out there gathering information, just not sending but trying to receive, right? So once you figure that out, be clear with your employees um, whether non-professional use is allowed on company. Do you let? I use this as the I say, are you going to let them display their personality? Talk about personal things, depart from the professional persona, or are they only allowed to say, look, hey, I'm a Johnny Company rep, and I'm here to talk about our products or service and to help you, and not engage with people about their personal life or other things. I've seen people use Facebook and Twitter for all those types of things in a professional context, and I'm not here to tell you that one or the other is preferred. I'm on Twitter quite a bit. My name is Scary Lawyer on Twitter. I chose that as sort of an ironic name, but I use that Twitter account sort of a mix of personal and professional. Um, and I do that because the law is, a personal service business, and no matter how many seminars I do, it's usually word of mouth that I and referrals that I get um, work from. So, um, you know, a lot of people find that off-putting if a professional just is pumping out basically electronic versions of brochures about themselves. Other law firms, other lawyers take a completely different view. I see other lawyers on Twitter that do, you wouldn't know anything about their personal life from following their Facebook page or LinkedIn or Twitter, and that's fine, that if they feel that works for them. But as an organization, you have to make that decision, okay? Um, and to what extent? To what extent? I can tell you our social media policy here at Buchanan Ingersoll and Rooney does allow the use of Twitter and Facebook and other things for both personal and professional reasons. But we all know that if we say something that reflects badly on the firm, we lawyers, it's not just a question that's applicable to lawyers, but we have proprietary information, confidential information. It's not just lawyers that have that issue, and I'm going to talk later about some examples from the news about some famous or not so famous misuses of social media that got people in trouble. Um, but so be clear about whether non-professional use is allowed in in the when they're working, and to what extent. Delineate off-limits topics. Um, especially Twitter, which is a microblog, but Facebook as well. It is it's online. It's immediate. You're in close contact with people. It engenders um, a lot of rapid communication, a lot of communication that's not polished, a lot of communication that may be spur of the moment, that may not be thought out. Uh, you should, when you allow your employees to use these things in a professional capacity, you should be quite clear, right? That, for example, if I was running a company, if I was running Buchanan Ingersoll and Rooney, and I wanted to have a really locked down policy, I would say, these applications may not be used to discuss personal business or other, other things other than the official business of the firm that we are permitted to disclose to the public. Like, hey, we're doing a seminar, or hey, the customer surveys came out and we did great. We were one of the top 10 firms, customer satisfaction wise, or, we want to announce the opening of our new office in Albuquerque. Or, those are the types of things that for a law firm, would be utterly, non-personal, utterly professional. And for any other business, you can think about what are analogous things. Um, do you want to do you want to let people talk about religion, politics, sports, current events, personalities? I mean, all these things are topics that, if you are indiscreet and you're just popping off, have gotten people in serious trouble. Think about Gilbert Gottfried. He used to be the Aflac Duck voice, right? Until he cracked some jokes about Japan in the wake of the natural disaster and the nuclear crisis they faced, and he lost that engagement. That's an example. Ashton Kutcher was has, I think, close to 10 million Twitter followers, right? He got a lot of hot water because in the wake of the Penn State scandal, he tweeted in defense of Joe Paterno. Now, I'm not really expressing one way or the other here, you know, whether Joe Paterno needs defense or not, but a lot of people um, were very offended by his comments, and so he ended up, retracting those comments. And one would say that that's a PR black eye for the guy. So I can tell you, those topics, um, politics, sports, um, celebrities, current events, things like that, um, generate a lot of strong feelings. They're typically not related to the core of the business, but people tend to talk about them on these things. So, in other words, you've got to communicate to your employees, and I would do that. What's off limits and what's okay. Now, the way you do this is you enact a written policy, a social media policy. Now, most well-run businesses are going to have already codes of conduct, employee workbook, handbook, or not workbook, handbook. You know, most companies with any kind of headcount are already starting to deal with, all right, how do I manage the risk of, claims by employees, improper conduct by employees, dishonest conduct by employees. In other words, misusing company resources. So to the extent you have an HR department or you have, um, any kind of policies, this belongs, the social media policy belongs right there with those other policies. Okay, and you should make sure that if you just because you catch the social media bug and you say, wow, I really want to go all in, I want it to be the Wild West, you want to make sure if you're allowing people to do that, that that's consistent or it doesn't conflict with other restrictions that you're placing on them elsewhere in your company procedures. No. Well, yeah, I spoke to. I mean, I trying to think. I tend not to because I am in litigation a lot. Um, I tweet about client successes. I'll retweet if a client is doing a seminar, or I'll give them congratulations if they say, hey, we just got the big contract from City Hall. In that context, when they're out there publicly, um, and also I know about, if I'm following them and they're following me and I'm doing work for them, we know typically the way I work with people, I have a personal relationship with them, to a certain extent. And I know that they would appreciate it, that positive publicity. So that's the kind of thing. What I wouldn't tweet about, I'll give you a list of the things I wouldn't tweet about. Um, my thoughts about the witness I just deposed. What a lying scumbag he was. You know, my irritation with the judge, who I was just before. Uh, Boy, to schedule the trial the Friday after Thanksgiving in St. Louis, where he knows I'm in Philadelphia, he's really trying to stick it to me. You know, or I can't believe the moronic verdict. This guy just award. I mean, these are all things. These are all things that lawyers have done. Um, and yeah, I certainly wouldn't say, wow, um, got a real sticky wicket type case for, you know, my big client, you know, um, the XYZ company. I mean, that would be most of the time, most businesses, uh, you know, uh, don't want publicized the fact that they're involved in litigation. Certainly not if they're getting sued. I mean, that in and of itself is typically a PR potential crisis that has to be managed. Um, I mean, there's all sorts of seminars on crisis management from the PR perspective. So to add fuel to that fire, and gasoline to that, I think that's poor practice. Lawyers have a professional obligation to keep client confidences too. So there are ethical restrictions on what I can say about a client or communications that I have with a client unless the client allows me to, you know. But again, it's when anytime I'm touching some third party or touching upon some third party with my comments, I am very, very careful. It's the same as if I'm in a public square, the public square of old. If I come in contact with some vendor or other party or actor who maybe I don't like, and maybe deservedly so, I'm just not going to do that, because if somebody, there are examples of people getting sued for defamation and not just defamation and trade, libel, but if something I say interferes with a potential contract or a potential business relationship, that's a potential tort called tortious interference with contract or tortious interference with prospective relations. But beyond what a lawyer has to deal with, I mean, there are plenty of us out there that are dealing with I told you what a trade secret is. If you're dealing with a customer and you have in your hands the customer's proprietary data, maybe it's not even a trade secret. Maybe it's just a list of clients. Maybe it's just a marketing strategy where the company wants to go. Um, you have to be very careful that you're not disclosing that. There are plenty of regulated industries too. Where there's patient data, and medical patient data, um, data about insureds, data about depositors, um, things like that. So you really have to think about, and it should be when you're enacting a written policy, you're going to enact a written policy with your business in mind. If you know that you, excuse me, are a law firm, or you know that you are an accounting firm, or you know that you are a PR firm, and you know that you have sensitive client and customer information, you have to set that forth in the policy. What are we allowed to say about customers? What are we allowed to say about, um, to say on behalf of customers? There was a recent example. One of the big auto manufacturers had a PR firm handling their company account, and somebody got confused and tweeted, well, it's ironic that Detroit is known as the Motor City, but everybody drives like morons around here. And that went out over the Twitter account of this large auto manufacturer. And so that employee was fired. The PR firm was not re engaged by this auto company. Um, so that is a situation where, and this was a PR firm, where they didn't rein in, they didn't educate their employees, and this has to happen before you let them start hacking away at Twitter and Facebook. It's like, hey, folks, here's the boundaries of what you can do and what you can't do. Okay, you have to also make sure that violators realize that to the extent you have escalating discipline and corrective measures in place for your other transgressions, that is those things are equally um, subject to discipline. There is also obviously a human element. I mean, that's what's so viral about these things. Um, you have to, if you're going to get the full benefit of these social media applications, you do have to engage in a little bit of, letting people go and trusting them that they're going to use common sense. But you have to, part of the education, part of the orientation, you might view it as the golden rule. Realize that you're going out, you're going to communicate with others in the same way you conduct yourself in a business meeting, internally in the company, with all the division president and all the managers and things, certain things you would say and you wouldn't say in such a meeting face to face. There is no difference in the online context. Certain things you would or wouldn't say when you visit a client's site. You wouldn't say it in an online. You shouldn't say it in an online context either. Further, what you want to do is you want to make clear in your policy and make sure that your employees know that the company is going to be monitoring the use of these applications, that the company reserves the right to add, subtract, withdraw content, and when appropriate, when somebody is going off the reservation, step in. And that requires somebody to be periodically and regularly monitoring the use of the Twitter stream or the Facebook page. So that's what I mean by an ombudsman. Somebody who has central authority for that, somebody who also can resolve disputes internally. Say, hey, Larry here has really been offensive with his comments about Sue, or he's been offensive to me, or he's been creating trouble. There should be some mechanism within the company to bring that situation to a head, and have action taken one way or the other. Disciplinary action, suspend rights to to the employee to use um, to use the application or whatever else is appropriate.
If somebody says something inappropriate, let's say somebody wants to like sue for defamation or something, is there some way to retrieve that? Is that always out there? Does it go away?
Well, I mean, depending on if it's if Google gets a hold of it, it'll be there for perhaps a very long time. I mean, there's um, I don't know the exact technology but once they
Like you Twitter something through your law firm, that's
right.
now your computer somewhere?
Well, it would be yeah, it would be on my computer. It would show up in Google searches um, indefinitely. Of course, there's a lot of noise. In other words, if you tweet a lot, uh, it's not necessarily clear to me. I mean, because Google changes their search algorithm, that much I know. So what would come up as relevant, or the most relevant things in a particular search, is going to change from time to time. But potentially, it's a very long trail. Things can stay around for years and years. Um, so some things that you should certainly consider, in my view, as far as a social media policy, um, prohibiting. So certainly, profane, lewd, obscene, or indecent comments. They're going to, it may be self-explanatory, but I do want to flesh out, both internally and externally. Internally, if you allow that to occur, as I said, it gives rise potentially to claims for hostile workplace environment. Um, if you allow that to be directed outward, it's going to reflect poorly on your company. It's going to potentially give rise to claims. Similarly, comments that are offensive, harassing, or embarrassing to others, you should have your employees think about what they're saying uh, in a business context, right? If you think about, um, when you have a face-to-face business meeting, there's certain things we know not to say to somebody if we have any sensitivity at all. But sometimes, because of the fluid, and immediate nature of an online environment, uh, people lose that filter. But there is, I can just say how I govern myself and how I see other people who are effective at using social media govern themselves. They're not taking opportunities to be negative. They're not taking opportunities to be insulting. They're not taking opportunities to be demeaning towards others, others' work product, others' results. I mean, you may know that some vendor is not very good at this or that, but the social media environment is not the place. It's not a good place to make that statement. Um, there is the next thing, invasive of others' privacy. There is in Pennsylvania, as is the case in just about all 50 states, case law that protects people's right of privacy. And if there are facts that a reasonable person would not want to have be made public, and someone goes out of their way to make those facts known, that somebody has a medical condition, or that somebody has some kind of situation in their personal life, or their financial situation. Um, if your employees are doing that about each other, if your employees are out there doing that about customers or representatives of customers, that can potentially give rise to claims for invasion of privacy. And especially because those it's known as an intentional tort. In other words, a tort is a civil wrong, and you can have unintentional torts, like you get in a car accident, right? Somebody was negligent. You have intentional torts, some intentionally wrong thing that you do. When it's an intentional tort, in other words, somebody intentionally spreads something about somebody that's supposed to be private, that gives rise potentially to punitive damages. Punitive damages are, as the name suggests, damages intended to punish for willful behavior. And again, that kind of exposure is not something you want your company to have. Um, Again, for the same reason, personal attacks on other users, um, reflective of animus or bias with respect to race, ethnicity, religion, or sexual orientation. Um, it is, it should be self-evident, but people, to the extent that they have these animuses or biases deeply in them and don't necessarily think about uh, that people might be offended by that, things come out. There was a case of a well-known sportscaster who lost his job because he tweeted about his comments about uh, what a quote unquote real marriage should be. Should it be confined to a man and a woman, or does a real marriage include same-sex partners? And so he had some opinions that he gave, and in that context, in connection with a story, a current event story, and he lost his job as a result. And apart from the disruption to his life, it's not something that his employer wanted, because that becomes a PR, a piece of kryptonite that they have to deal with. It becomes a PR crisis. What is the appropriate response? Are people going to be happy with our response to the nasty comment? You know, will they think less of us because we didn't go far enough or we didn't move fast enough? And that's just not something you want to have. So again, educate people in advance. Defamatory or disparaging, it's not most of the time, apart from the civil liability that arises, it's typically not good business. If you see somebody, if you see a professional, I know myself, if I see a professional or a vendor who seems to believe that he, she, or it, has to interact and build up their business by mudslinging against other people, I've found that other professionals and other customers and clients don't really have a very good view of that. So you have to have your employees educated on that fact. Knowingly false and misleading comments raise a whole other host of issues. Um, to the extent that you make statements, um, a company's out there, an employee's out there making statements on behalf of an employer that are knowingly false or they're potentially misleading, that can give rise to claims of fraud. If somebody reasonably relies on that representation, yeah, our lawnmower, we're the ABC lawnmower company, and yeah, you can run it up an incline because the blade never flies off, or whatever example you want to use, or yes, our product will do that, or no, you won't experience that kind of problem with our product. If somebody relies on that, and that statement is made in the context of social media, that could potentially give rise to claim for negligent or intentional misrepresentation. So you need to keep track of what your employees are saying about your products or services, are saying about your company's intentions, are saying about what your company's going to do and not do. Um, if you're if the business is publicly traded, in other words, that they have their securities, they're selling securities on a public exchange, there are a whole other host of issues. To the extent that you have your representatives or employees talking about the future prospects, things are looking great. It's going to be a record quarter. We're expecting very big things from, such and such division. Things are looking up, moving more product, selling more product, things like that, that investors could be reasonably expected to rely upon, right? You have potential liability under the Securities Fraud Act or fraud, laws about that. So when you're in the publicly traded context, that is very important. There's certain safe harbors that with respect to quote unquote forward-looking statements that you need to take advantage of. And so that's another thing if you have that issue. There are, as I mentioned before, there are plenty of companies that are in highly regulated industries. So you've probably heard of HIPAA, Health Insurance Portability and Accountability Act, and that regulates what can be done with personally identifiable health information and health records, right? So if you are, a company whose products or services touch upon uh, patients, medical patients, um, to the extent you're out there employees talking about this situation or that situation, they have to make sure they abide by that. Um, there are other things, Gramm-Leach-Bliley Act, um, applies to financial institutions, imposes data security obligations there. There are um, other highly regulated industries. So you need to know before you let people go and deal with social media, you need to know what statutory or legal obligations are on us with respect to what information can be disclosed, right? And that has to be hardcore, ironclad, off limits, right? If that's not in your policy, that's a major gap. You're really playing with fire. Uh, a lot, now plenty of the economy, a significant portion of the economy is not necessarily um, highly regulated specifically, but you're going to be touching proprietary or confidential information from your customers, your vendors, commercial partners. I mean, as to your question about clients, you know, um, there's all sorts of things, um, all sorts of situations where I might be negotiating a contract and I'm very excited about it. And, I mean, wow, it's going to be a great deal, but I can't say, wow, such and such a client's about ready to sign a deal with MTV, you know. Um, After the fact, after it gets publicized, if the client allows that, if MTV allows it, I mean, that's just an example. I had somebody, many years ago that did that, and that was great. And we publicized it. That was actually before Twitter was really around. But um, that kind of thing. Customer strategy. Sometimes people use Facebook and Twitter to sort of vent, as I said before, about frustrating situations. And those are the things where um, even if even if third parties can't, I would say this, even if third parties can't identify who it is, if the client is following you or the client representatives are following you, even if there really isn't any harm, it's awful for them, and it can kill a relationship. You see, Frank, last night you're tweeting about our deal that you're doing. Who else are you telling? You know, how do I know? Some night you're not going to go farther with that. So even if there is no legal liability, as an ethical thing, as business, people to the extent you're interacting with clients over this and they know you're there, you have to be very, very careful. Um, to the extent you have employees out there talking about what the company is doing, you know, the company may have an interest in saying, look, here's what's new at XYZ company. We're rolling this out. We're developing this new product coming soon, next spring. You know, that's fine if that's consistent with the strategy of the company. You know, to let the public, the consuming public, know what's coming, right? And that'll vary from situation to situation. But there are plenty of times where things are too fresh, too new, too experimental. That the company doesn't want to see, have see the light of day. And so you have to have in advance, if an employee is going to be talking about something, that employee knows what's off limits and what's okay in that area. Also, um, to the extent, this next bullet point, infringing on the intellectual property or other proprietary rights of others. This happens a lot in the online context. If you copy somebody else's material and you post it anywhere, most likely you are infringing that person's copyrights in that material. Um, to the extent that you're um, using their trademark, that's potentially creating customer confusion about who's associated with that communication. That is a potential source of liability.
I have a question
Sure.
about that.
Yep.
A lot of written material has the words copyright, 2011, whatever company. If you don't have that writing, does it matter? Or?
It does not matter. Now, there's the most recent version or overhaul of the Copyright Act occurred in 1976, and to conform with international law, that C in the copyright is not required as a prerequisite to preserve your copyright. People do it for a couple reasons. It scares people off from copying. It'll also allow, under the Copyright Act, if you can prove that copyright infringement was willful, that is intentional, you are potentially in line to get greater remedies. There's things called statutory damages where if you can prove willful copyright infringement, you can get up to $150,000 per work infringed. If if there's non-willful infringement, that it's capped at $30,000. Right, so it's a big difference. So, um, most of the time I'm advising clients that if they care about their copy, I put out plenty of things like this presentation. It's out there. It's on the web. I don't care. I'm not trying to make money off my PowerPoint slides, so I don't bother with that. I consider it in the public domain. But other service providers do, and so before you, what I tell them is if you intend to make a sort of distribution of this to the public, you want to register. And I don't want to turn this, into an intellectual property lecture necessarily, but if you register a copyright, if you register a work with the Copyright Office before you publicize it, before you publish it, you're in line to get statutory damages if there's infringement. Where you wouldn't necessarily be able to get those, you'd actually have to prove actual damages if you registered it after the infringement. I'm simplifying it, but if you put it out there and you register it after the infringement occurs, you might not be able to get statutory damages. Also, if you register it before and you prevail in the litigation, you can get your attorney's fees paid for by the losing party. And obviously, that's a big hammer when if you do that. Let's say you're um, you're a graphic artist, you're putting out designs, you're doing clip art, or um, you're going out to the public with certain types of designs. If you register them before you publish, then you know from the get-go that if somebody infringes, you can have your attorney write them a letter like, look, here's what's at stake. If you don't immediately stop, we will come after you for not only your profits, perhaps your statutory damages, and we will get our fees. So,
If you properly cite, if somebody writes a blog and you just copy whoever wrote, or a newspaper article, and you actually cite who wrote it, when it was written, where it came from, and a link back to their blog or website. I thought that was legit to do that. I hope it was legit because I gotta.
well, it implicate what it does is there's a doctrine called fair use, and fair use is that there's certain types of copying that are okay, even though it's literally an infringement. I mean, if you copy somebody's stuff without their permission, even if you say, yeah, it's this person's stuff I'm copying. I mean, that's tech, technically or not technically, that's you're infringing their rights. But you would have a fair use defense if, for example, I'm a college professor teaching a lecture about something, and I say, let's look at this Lady Gaga song. Let's look at the lyrics here about, and I find deep societal meaning in this, okay? And, put up there, I would say, well, I'm not trying to make money off it. This is for educational, literary, scientific, um, you know, nonprofit purposes. And it is not an absolute defense because sometimes nonprofit institutions that are making money off authors' works can get sued, and the fair use defense doesn't work. But there's certain factors that make it more or less likely. And if you're not making money off it, if you're not taking market away from the author, in other words, if you're making money that the author would otherwise made, then you're in trouble. So that's a case by case. Obviously, if the quantity of the work that you copy, I mean, if you take a few lines out of Lord of the Rings, it's just like 1,000, 1,500 pages or something. That's one thing. If you have it up there, here's chapter 10 from the book. That's more substantial, and the court's more likely to find, that you're infringing. But uh, when you are hosting, if your company is hosting a site, and let's say you have a blog, where you allow user posts. I'm going to have a WordPress application and people can comment. And you've seen comments on the internet. People will do all sorts of things. Sometimes they'll just write, a few words or a few sentences. Sometimes it looks like a book, and they'll post content. Say, hey, look at this picture, whatever. As the host of this service, you have potential liability as a contributory copyright infringer if you're posting that material, and if you're allowing that material to remain, and the poster took it from someone else and didn't have the right to do it. All right, so that's why this stuff, if you're going to have, whether you're operating your own blog or site or whatever, and it's your company's URL, you have to monitor that. There's something called the Digital Millennium Copyright Act. These are amendments to the Copyright Act that occurred in 1999 that sort of give a safe harbor for this situation. That is, you designate a what's called a DMCA agent and say, hey, if you see infringing content, you'll see these links all over the place. So look at any most well-written, well-lawyered website terms of service. They'll say, there'll be a link for DMCA policy. What that means is if somebody contends that there's infringing content, you give them a name and an address and a person to lodge that complaint with, and your obligation is to, once you get that request to take the content down, you take it down, you inform the poster, hey, someone objected to the things you posted, and they get a certain number of days to either be silent and not try to repost it, or say, no, that is my original stuff. That claim is bogus. Please put it back up. Once somebody sort of counters that, then you're off the hook. You say to the original complainer, pursuant to the DMCA, the poster has contended that it's her stuff or his stuff. I don't have to take it down unless you go and get a court order. That's how it works. If you're not doing that, you potentially lose the benefit of that safe harbor. So that's basic blocking and tackling. If you're going to maintain your own site with these types of things and allow employee or third-party content and posting to have a DMCA link on there. And then similarly, if you have employees out there running wild, you know, taking things and posting on third-party sites, and they're doing it in the scope of their employment, you're going to potentially have vicarious, liability for their activities. So you're it's part of good business practice to educate your employees on, what is, you know, uh, what does copyright infringement mean? What does trademark infringement mean? Copyright um, infringement means unauthorized copying, display, modification. So if I take something that somebody did and modify it and put it up there, just because I changed it a lot or a little, still it's called a derivative work, and you have potential liability for that. Um, Sometimes you have both internal or external risk. If somebody um, is particularly technically adept and puts files in there with malicious code, or it crashes a site, crashes a competitor's site, crashes a third-party site, and they link that back to the activities of, your employees. Again, that can give rise to claims. Um, there's a Computer Fraud and Abuse Act that might cover that. There's criminal statutes that can intentionally apply, and the good old tort of intentional infliction, or not intentional infliction, tortious interference with contract or tortious interference with business. If somebody's got an e-commerce site and your employees do something to disrupt that, um, there's potential liability that would apply. Um, certain certain housekeeping things internally that you want to do with users, you want to make sure you know internally, if you're going to allow employees to have accounts, who is acting, who is posting. So you don't want to you want to make sure it's prohibited. Not that it never happens, but you don't want to allow or permit from using other people's accounts, impersonating other people, using anything other than their real name. If you should give some thought to requiring some degree of identification from third-party posters. Again, unauthorized disclosure of information. You've got to make sure that people, if they're in possession of information from third parties, that they don't disclose it without permission. Now, the next topic is when somebody, if you're going to allow or solicit or encourage third parties to post on your site, we've all seen these terms of service, Twitter, LinkedIn, Facebook, we all click through them and ignore them, or a lot of us do. But you can bet dollars to donuts that they all have quite detailed treatment of who owns the intellectual property rights in that which is posted on the site. Not only ownership, but um, they deal with licenses too. A license, legally, all a license means is it's permission to do something. Okay, so even though if your company owns a site and you're allowing your customers to post things, I mean, you might not want to say, okay, our terms of service are such that we own what you post. All right, that's not necessarily good business, but you may want to clarify that if you if you put it there, you give us the license to do certain things with it, right? And depending on the type of contribution, you would want to reserve the right to do certain things. Certainly, the right to remove it if it's offensive or actionable. You want to reserve that right. Um, you want to reserve the right to modify it or change it if it's necessary to protect against claims. Uh, some people, if you want to be using these social media applications to collect useful data, market data, you want to reserve the right, in your terms of service, is that, please know that, we reserve the right to use this information for any, legitimate business purpose of ours, so that if you tell us, your experience in using our lawnmowers, or your experience in, or preferences with respect to vacuum cleaners or dishwashers, we reserve the right to use that. We reserve the right to, what I've seen, use your posts in advertising to publicize this site, to publicize our services, and all that. Um, if somebody's contributing technical information, you may want to take the position that we own that. We have the right to exploit that that information. You want to, and so just to clarify, because it wasn't clear, if you have an outward facing, even if it's certainly if you have an outward facing, but even if you have an inward facing to employees, you want to make sure there's clarity about, if an employee contributes things, who owns that? Is the company claiming it? Because sometimes, employees have technical knowledge that they've developed from their past job or on their own time, and you don't want to necessarily get in disputes with employees about, well, so and so in the company blog or wiki really set forth some novel procedure, and here the company thought, hey, well, that's our stuff, we're going to use it, only to have the employee says, no, you know, I developed that outside of my work with the company, and I own that, right? That's an internal threat that you can avoid by having guidelines in place. When it's outward facing, when it's people, and you can make that part of the employment relationship, you know, and should. When you have the uh, application be outward facing, people you don't have an employer relationship with, you should use terms of service and say, look, if you know, whatever it is, you know, we reserve the right to complete, you know, we consider it our property if that's what you want to do. Um, you also don't want, um, uh, you want to regulate the use of your trademarks. In other words, you want to make sure that your employees know what's appropriate, you know, use of the company's marks. And you also want to reserve the right to regulate, you know, if third parties are coming in and improperly posting marks of other people or doing things that might give rise to third-party claims, that you have the right to stop that, to remove the content, to preclude their further participation in the application. You also want to get warranties and representations from the parties that they have the right to be posting what they're posting. So in other words, you're asking them to say, okay, by clicking yes, I agree to the terms of service, you agree, you represent to me that you have the right to post this, that we will get indemnification from you, that if we get sued, you will hold us harmless if we get sued because you didn't have the right. Also, get representations from the users that what they're going to post is accurate, not misleading, not actionable, not, you know, that it's not, they're not violating other people's rights by doing it. Uh, this last bullet point here, to the extent that you're going to allow um, employees to be out there, you may require them to say, okay, my comments are mine alone and not representative of my company, where that's the case. There's also cases where they need to disclose that they are working as a paid representative. The FTC has blogging guidelines, blogging endorsement guidelines, so that if you're out there, if your employees are out there in the world, social media, singing the praises of your product, but not disclosing the fact that they're paid, you have potential liability for that. So you have to make sure they are acting transparently and ethically in connection with their endorsements of their own company's products. Um, I've been talking a while. I wanted to leave plenty of time for questions.
We've talked about some sites that are all lawyered up. Can you recommend ones that I can look at?
Well, Facebook, Twitter,
Uh-huh.
those are very thorough terms of service. I mean, you will see in a terms of service, um, you know, you'll see all these things that I went through. Uh, you know, what a terms of service will do is it'll say, look, this governs your use of our application, and um, it'll say it'll set forth what they have to do to set up an account. In other words, you got to use your real name, or you can't use an anonymous name. You can't use an offensive name. Sometimes people do crazy things. You know, their username is, either infringing somebody's trademark, or it's offensive, or it's obscene. They do that. There's usually a list of things like on this slide. You agree that thou shalt not do these following things. Um, they would have further. Um, there would be quite a bit of treatment of intellectual property issues. In other words, you as a company, you want to make sure that you're able to um, do with that information what you intend. So that has to be set forth in terms of licenses or ownership. There's going to be, um, in addition, indemnification, warranties, releases. You want to get as much of a release as possible for people. words, you say, look, you agree not to sue us, our employees, because of things that happen to you on this site, because of the things that other third parties, in other words, they're not just interacting with you in these applications. They may be interacting with other third parties over whom you have no control other than you've made them sign on to the terms of service or terms of use. So you want your users to release you from claims um, that arise from your employees' interactions, but also other third parties. To the extent that you're allowing uh, access or you're linking to other third-party sites that aren't within your control on your site, you want to make sure that you are disclaiming any involvement with those sites. In other words, you're saying, you agree that um, this application may make available to you links for third-party sites and other things. You understand that we make no warranty or representation as to the truth or accuracy, suitability of the information that you will see on those third-party sites to you. Because what you're doing is you're trying to cut off claims about, well, it's kind of an implied endorsement. In other words, you guys say you're a reputable lawnmower company, and you link to some research institute. And I went there, and I followed what they said, and I got all cut up. And so you you know you knew or should have known that I would have relied upon that implied endorsement. And you'll see, in strange enough cases, excuse me, you'll see that kind of thing. As I said, good terms of service will have representations. They'll be saying, look, I have the right to post this stuff. This stuff is mine. Either I own it or I have the license or permission um, of the third party who does own it. Let's see, what else would you typically see? I mean, those are the main things. Um,
Is that in defense if somebody sues you, like somebody uses copyrighted stuff and they say, well, I own it, and it turns out they didn't?
well, what they've done is they've made you a if they're posting on your site, they've made you a contributory infringer. Um, Contributory infringer under the law means it's not somebody who's the direct instigator, the original person, but you're materially aiding and assisting in the infringement. And realize that in the copyright context, all you need for copyright infringement is displaying it. And so obviously in the online context, very, very easy to infringe because if it's not your stuff and you have it up on a website, you are potentially infringing. And even if you change part of it, all you've done is made it derivative work, and the copyright owner has the right to prevent derivative works. If you send files to people, you're making distributions. That's another form of copyright infringement. In other words, copyright owner has the absolute right to control distribution of a copyrighted work. So when you have that stuff and you allow that to remain, you're contributing. And so the reason why the DMCA was, in my view, a very necessary act is that in this context, it's very easy for a company if there's a lot of content and a lot of people interacting and it's all being updated and changed in real time, for you to be unknowingly infringing. And so that's, like I said, standard blocking and tackling. You have that link there. You have that procedure for DMCA. It's called a takedown notice. Say, dear sir, madam, that's my content. Please take it down. And your obligation is to act with reasonable diligence in dealing with complaints like that. And as long as you do that, you should be okay. Um, but strictly speaking, it's not if you ignore it. If you blow the person off or you don't take advantage of that um, safe harbor, it's not a defense. If somebody can, as between you and the person who posted it, you want to make quite clear that they represented to you through the terms of service that they had the right, so that you can get sort of contribution from them. And I mentioned indemnification in one of the slides. Let me explain what indemnification is. Indemnification is an agreement to cover somebody, to make whole somebody who gets sued because of something that you did wrong. And so part of what you're going to see in most of the terms of service is, as a condition for using this, you agree to indemnify us against any and all third-party claims that arise because of the content you post or your activities, in there. So you try to protect yourself that way. Now, as a practical matter, if the web is worldwide, and if it's an individual person who happens to be in Bolivia and who doesn't have substantial assets, you know, you, the indemnification might not be, practically, um, as useful as if it was a substantial company doing it, in your backyard, which is why the DMCA takedown procedure and all that is so much more important. Um,
Well, I hear ads on the radio for companies say if somebody says something bad on you on the internet, we help you get rid of it. Is that possible?
well, you can have the content removed, from the live site. Um, I have heard of people, going to Google and some of the search services to try to get them to, I don't even know what the term is, decouple or delink it. It is possible to certainly to remove or narrow the footprint or make it a lot smaller, you know, and in some cases, um, to remove it entirely from what I've seen, you know, and it's I will say something else about people. We do have a First Amendment right, a limited First Amendment right to anonymous speech, and that includes speech on the internet, but it is limited. And if you are infringing somebody, and some of the main limits to that relate to intellectual property infringement and torts like defamation, slander, libel. So what I mean is, you could be posting anonymously, but if somebody says, "Hey, I don't know who Edgar 397 is, but I'm going to find out," and I've done this on behalf of people. You file what's called a John Doe action. You you don't know who you're suing yet, but you sue in a court, and then you say, "All right, Your Honor, we don't know who John Doe is, but we would like leave to serve a subpoena on Twitter, or serve a subpoena on um, Yahoo, or whoever, whatever ISP, or it's possible to get the to the carrier with whom the person has given real life credit card information and all that, so you can track people down. I had a couple cases arising out of, I don't know if you guys know anything about virtual world technology, but Second Life. It's kind of like Worlds of Warcraft, but it's not so much a game. And there, I had to sue an anonymous user of that, and all I knew is that I had a client in Tampa who was getting ripped off, within this gaming environment. They were taking his content. So we ended up doing a John Doe action and found this guy in outside of Fort Worth, Texas. He was completely anonymous until we served subpoenas, and we found out it was Southwestern Bell or whatever that company, and we tracked the person down. So the if you're a wrongdoer on the internet, absent being outside of the jurisdiction of the person who's coming after you. I mean, obviously, if you're in Romania and you're doing something to somebody in the United States, it's a lot harder. But in this country, you can be, you will be tracked down.
That happened recently with George Perry.
I did not hear about that. What?
There was a blogger who was anonymous who was basically trashing some of the high-end
Right.
restaurants, and he had defamating, I guess, comments towards George Perrier, and eventually, within about 2 weeks, he was found out and exposed.
Yeah, and the what you have to do in that situation is you sort of have to show the court, I have a legitimate claim here, and there is a gatekeeping function in the court. I mean, if you want to expose, I mean, there's limits to what is defamation and what's not defamation. Expressions of opinion, um, just legitimate disagreements are not necessarily defamation. and um, a court's going to look at. You have to come into court and say, Your Honor, here's my claim. Here's why I want to issue the subpoena, and the the anonymous person can move to quash. What's called move to quash the subpoena. So what will happen is the service will, if it's an anonymous user, you're using Twitter or whatever, you've given your real life information to Twitter. Twitter's going to contact you once they get hit with the subpoena. And they're going to say, you know what? We've been served with a subpoena. If you don't object, if you don't get a lawyer and object within 10 days, 15 days, we're going to release your account information in response to the subpoena. So it's at that point that if you're in that situation and you feel you have a legitimate defense, you lawyer up, and your lawyer files something on behalf of John Doe saying, it's either not a legitimate claim or there's legitimate privacy issues here, and they're not often successful. I mean, you've probably heard of the RIAA, Recording Industry Association of America, going after people for file sharing, peer-to-peer, things like that, and that's it's done all the time. Done all the time.
Now, what if someone creates a fictitious name on a Twitter account with a fictitious email? I mean, how do you track someone like that down?
Well, that's harder, but what you would do is what we did in the Second Life case. We started with you would serve a subpoena on the service itself, that is Twitter, because typically what's going to happen is there's going to be an internet protocol or IP address that's associated with the user's interaction with the service. And so then you get that IP address or range, and then you can do a reverse lookup to see, okay, you track that back to what carrier is that person on, and then you subpoena the carrier and say, I want the information, I want the user information for, these IP addresses. That's what we did. In our case, we subpoenaed Linden Research, who runs Second Life, and we had the avatar. It was kind of a goofy, not kind of, it was a goofy case, but what we had was an avatar name, and in the virtual world, he appeared as some kind of furry animal, and we said, we 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 want the IP addresses associated with guy's avatar name is Volkov Cataneo. I'll never forget it. And we want the IP addresses, and also we want all other account information. Now this guy gave bogus information, right? So there were a couple of red herrings, but he couldn't fake the IP address, and so there were two different computers that he used to do this conduct, and from two different carriers. So we were able to track down account information to two different houses, 3 or 4 miles apart, outside of Fort Worth, Texas. Right? I just called up both houses, right? And I was able, through talking to the people, to say, yeah, we got a friend who came over and plugged his computer in. He stayed with us for the summer, and yeah, he lives down the street. So that's what can happen. Now there are more sophisticated, if you're doing IP spoofing and things like that, or there are some cases where it would be harder. But if somebody has enough resources, they'll typically find you. Any other questions or issues or concerns you have? All right. Well, if not, I'll stick around for individual conversation or questions. But I appreciate your time and attention, and hope you got something out of it. If you would like a copy of the PowerPoint slide, just come up to me, give me your email, and I'll certainly email you a copy of the PowerPoint slide. Um, and again, thanks for coming.